Hi, uh, good evening, everyone, and welcome to today's webinar on restrictions on cross border data transfers and the growing use of data policy as a national security tool. I am Shubham Tripathi. I am a principal associate with the corporate and transactions team here at Hammurabi and Solomon Partners, and I'm delighted to be moderating this session as this topic now sits at the intersection of privacy, trade, cybersecurity, sovereignty, and geopolitical risks. What makes this conversation especially timely is that major jurisdictions are moving in different directions. For instance, the European Union, it continues to use a right-based system, which is in opposing to what the United States has. It has increasingly treated bulk sensitive data as a national security issue. And on the other hand, we have India and our DPDP framework. It adopts a more flexible but still evolving approach to cross-border transfer. With this, I would like to introduce Mr. Rahul Jain, who is a partner with Hammurabi and Solomon Partners, and he leads the Bangalore office, and he is the TMT and data privacy partner here with the firm. So my first question goes to Mr. Jain. So, sir, my first question is about the practical reality for companies operating across borders. When a business in India receives European Union or American personal data, what are the most significant legal and commercial pressures it now faces, especially when foreign rules increasingly frame certain data transfers as national security concern rather than just internal privacy matters. I would also be interested in knowing whether you think that this trend is forcing companies towards more regional data architectures, localized processing, or more segmented vendor arrangements, and whether this is becoming the new normal for cross border operations. Off to you, Mr. Jain.
Thanks, Shubham. And I think this is a very much relevant topic today. And Data is the new oil, and we know that it is also an asset. And in some point of time, it will be part of the books of the companies as well. So, very apt question at this point of time, because here we are talking about how the data is being cross-bordered, say from India as a source country to destination country, say in Europe or say in US. So of course we need to deal with respect to the all the three jurisdictional countries. First, I will talk about how the European Union is taking the transfer of such data and what is the implications for the Indian companies when, say, European Union or receiving countries in Europe. So we need to understand what are the adequacy requirements as per Section 45 of GDPR, wherein you need to be a adequacy requirement country in order to receive such data in the European Union. So European Union has a framework wherein adequacy requirements needs to be identified, which means that there will be a rule of law, there will be a legislation within which that rule of law will be followed, and there is an authority which takes care of the legislation and follows the rule of law. Secondly, we need to also understand the US law. US law is primarily with respect to Executive Order 14117, which is actually by the Department of Justice, which talks on the data security program, which reflects the US government's policy and approach with respect to treating bulk data. So here, when we are transferring data, then there is a standard contractual clauses requirements with respect to GDPR, which needs to be followed. Um, of course, these are the clauses which needs to be part of your data processing agreements. And since you have talked about the security concern, for national security concern, there is an additional safeguard or a guardrail which is required with respect to transfer impact assessment obligation, because of course you are having all those requirements in terms of uh, standard contractual clauses, but when the state surveillance laws comes into picture, that impact also needs to be assessed. Definitely, with which the European Union is asking for a transfer of data. Additionally, there are supplementary safeguards with respect to encryption, pseudonymization, localization controls, restricted access environments, and enhanced audit rights, which were in addition to SCC, needs to be identified, because equivalent protective measures needs to be given. So I'll also reflect you in one of my earlier clients. I have handling this situation wherein the parent company is in US and the subsidiary is in India, and it has been acquired. It was a recent acquisition by the US parent, and they were asking for the this is I think before the DPDP Act came into picture. It's 2000, I think 18-19, wherein we have identified that if the personal data needs to be moved from, say, India to US, then you need to have contract in place. That was the requirement under the SPDI rules 2011 earlier. So having said that, I believe that you need to have these SCCs, these additional supplementary measures. You need to follow the Executive Order 14117 and Data Security Program, because this is with respect to the certain types of data, which is, say, um, genomic, biometric, health or financial data, or data with respect to any kind of due diligence or audit rights. So I believe that, considering the fact that states are sovereign and they can have their surveillance
Mm-hmm.
power in terms of encryption and all, they would
Right.
be able to get the access to such data, and then therefore transfer impact assessment needs to be taken care of in such scenarios, so that
Mm-hmm.
you are able to take care of such situation. And also, I would like to finally highlight this Scrimshaw 2's judgment, wherein European Court of Justice has held the US EU-US Privacy Shield as invalid, because it was not able to understand the transfer impact assessment, and it was able to say that it has upheld standard contractual clauses, but EU Privacy Shield has been held invalid as per this particular judgment, and because of the uh, uh, wide powers of the United
Right.
States surveillance laws.
Right. Okay. Quite insightful, Mr. Jain, I must say. Now we are off to our next speaker. We have Mr. Scott Loughlin, who is a partner with Hogan Lovells, and he is going to be the next speaker. So the next question is directed towards you, Scott. So, as we all know, traditionally, United States, and famously, if I may add, United States has historically been very open and innovation focused, but now increasingly attentive to sensitive data, access, and national security. For our audience, could you now explain what actually changed in the regulatory mindset and why this shift happened now? When businesses hear that America is focusing more on data, they often assume that this is only about privacy. How should they understand the broader policy picture, especially the interaction between state laws, enforcement, supply chain concerns, and geopolitical risk? And further, could you also explain why certain sectors or types of transactions seem to attract more scrutiny than others? It would be helpful to know whether this is mainly a data localization conversation a transfer conversation, or something even wider? Off to you, Scott.
Yeah, thank you and appreciate your having me on your program here. And it's great to meet everybody who I haven't been able to connect with. I think as you were mentioning, I'm a partner at Hogan Lovells in the Washington, D.C. office. I co-lead the global data privacy and cybersecurity practice here. And one of the areas of focus, and specifically around changes in the United States, and frankly, that will have application to the global data ecosystem, is how the United States government is thinking about the transfer, the cross-border data transfer of personal information. As you mentioned, the United States has historically always seen it as an area where we're going to foster innovation and we are going to allow for the free exchange, the free movement of data across borders. And so it has resisted similar styles of regulation that you see in the EU or that you see in China or in other places in Asia Pac or even in Latin America, and has allowed for the transfer of data outside of very specific limited circumstances. That has now changed. And it's changed pretty dramatically, both kind of at the levels of the federal government and at the state government, where both levels of government are focused in on how personal data moves out of the United States, and in particular to countries that have adversarial relationships with the United States, and what impact that could have on specifically national security. So that's an important thing to double down on. Excuse me. Their focus is on personal data, which sounds like a privacy issue, but it really is focused not necessarily on trying to protect the individual rights in the same way that the EU does. It's not focused on trying to protect the rights of specific individuals, but instead on the national security of the United States. And that's really been highlighted maybe in two different ways. As I mentioned, the federal government and at the state government, both of which have been focused on this. There was a reference to the executive order, which has then produced what the Department of Justice calls the bulk sensitive data transfer rule, or the data security program as it's come to known. And that has broad application. In some ways, the name here is a misnomer. People think of it as saying, well, the data I have is not particularly sensitive. The data that I have is not really that large. It's not necessarily bulk. And by the way, I'm not really transferring the information. All I'm allowed to do is be able to access the information. And the answer to that is wrong, 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 because the application of this rule goes much more extensive than just whether you would think of as something as data that's bulk or that data is particularly sensitive. For example, this is the data that's considered bulk and sensitive. You'll see some of this data would be think of as particularly sensitive, like genomic data, biometric information, and geolocation information. And that is right. However, you start going into other categories like personal identifiers. Personal identifiers includes a name plus an IP address, like a name plus an advertising ID. All things that are quite common, especially in the digital ecosystem. And so calling that sensitive is really not exactly right and not necessarily consistent with what a layman would think of, nor is bulk considered really all that difficult to achieve either. With some specific sensitive information, it can be as low as 100 people, and then for some larger categories, it's 100,000. But regardless, I think these are categories that most global organizations will easily trigger inside of their operations. And once you start looking at saying, all right, well, it's bulk sensitive data, but we're also about transfer, transfer here means effectively access. It is not only the ability of actually transferring information from one hard drive to another hard drive or one server to another server, that's included. But it is what the government describes as the mere possibility that somebody would be able to gain access to data from that third party. So, in other words, how is it that somebody who can be able to look at the infrastructure of a particular IT system and then be able to manipulate that system to be able to gain access to data, whether that's remote access or whether that's physical access, it doesn't matter. All of that is going to be within scope of the rules. And we are now not thinking only about transfers of data to a specific country. Countries are included. So if you would think of like North Korea, Venezuela, Russia, notably China is on this list, which has deep economic ties with the United States. But it also covers individuals and organizations that are subject to the laws of those countries. So, in other words, you have an organization, a company, a partner that is based in China that would be covered by the rule, or an employee who resides in China that would be covered by the rule. So, it's a very expansive notion all around, how we are protecting the national security of the United States.
Oh, thank you, Scott. There's something I would like to point out with the list that you have. We also have such a provision, which is Section 16 of our Data Protection Act, that also mandates for such a list to be notified by a central government. It has not been notified thus far, but we expect it to be notified soon. Tying on to it, I have another question to Mr. Jain, which is sort of a continuation of this conversation that we were having. So now we talked about America. Now we turn to our own model. Section 16, like I mentioned before, of the DPDP Act, it allows cross-border transfers unless the central government restricts them to be notified countries or territories. We do not have it right now, but we expect it to be done in the next coming months. Now, this is a more flexible design than European Union's adequacy-based approach. The policy question, however, is whether this selective restriction model is enough to protect Indian citizens' data in a world where foreign governments increasingly claim national security reasons for accessing commercial data. Put differently, it is a negative list system. Is it, however, sufficiently robust if the real risk is not only unauthorized private misuse, but also lawful access by state authorities abroad? I'd like you to reflect on whether India's approach strikes the right balance between sovereignty, digital trade, investor confidence, or whether it leaves too much to executive discretion without enough transparency standards or predictable transfer rules. Off to you, Mr. Jain.
Thanks, Shubham. So I think here we have to read Section 16 with Rule 15 and of the Indian Data Protection Act 2023. And definitely, this negative list approach is opposite to the European approach of adequacy requirements, wherein countries needs to get listed in that particular format. I believe that since India is a developing country and definitely we want to be a AI hub, um, to balance the economic openness and to proliferate the global digital trade and growth of the IT companies, IT outsourcing sector, while retaining the sovereign authority, it is very much important that we need to have a negative list, which is basically a targeted restriction. And of course, you may echo with the understanding that we have the same kind of list for Press Note 3 with respect to investments as well. So, definitely, till the time there is no notification coming from the government. It's a negative list, so I think all the countries are allowed in terms of any kind of no restriction zone. So we don't have any kind of restriction vis-a-vis GDPR framework with respect to adequacy based transfer regime, or there is any kind of transfer impact assessment. But we need to understand that we have the framework wherein uh, similar kind of standard contractual clauses or binding corporate rules needs to be followed, because when you are having such kind of contractual clauses, you have understanding that your personal data of the citizens will be safeguarded. Definitely, if you see further under Rule 15, with respect to any kind of general or special order, the state can restrict the access with respect to any kind of foreign state or person or entity or agency in the destination country. So I believe that it is a need to understand basis we have this kind of provision which needs to be identified, because when you are trying to have these data, it has to be easily made available to everybody. And definitely there is a con with respect to there's no adequate transparency standards or independent oversight mechanism, and which may reduce the framework's effectiveness in protecting Indian citizens' data from disproportionate foreign government access. So, of course, that kind of thing is there. But having said that, I believe that extensive data localization burdens and facilitate, which will not facilitate the global digital commerce and provides regulatory flexibility in responding to evolving geopolitical and national security development. So, I think this negative list on a need to be basis needs to be notified, and therefore we are trying to make this as a global environment for the basically allowing economic openness and balancing that we need to have these kind of targeted lists only on a need basis, and not at the beginning level, like we are having in Europe as an adequacy requirement.
Right. Thank you, Mr. Jain. It, this cross-border transfer of data always such an interesting topic to talk about, especially when we have clients that are multinational corporations having businesses in European Union, America, and India as well. So quite interesting. Thank you for your answer. And now we go back to Scott. So I have a few pain points, uh, just enumerating them out here. We have lack of clear data visibility, fragmented global systems, like we have GDPR, DBDP, and again, America has their own state laws. And there are also confusion as to what constitutes as a transfer. From your experience, I want to know which of these is the most common failure point when companies first assess their exposure. Many businesses, they believe that they have compliance because they have policies, but the actual flows may be very poorly understood. How do you practically help a client from a policy based understanding to a real operational map of data access and movement? You also mentioned architectural designs before, which are intended to reduce friction. In practice, what does a better architecture look like when a company is trying to satisfy both business efficiency and regulatory expectations? So, off to you, Scott.
Yeah, very good. I mean, I think those are the pain points as you were just referencing them, and I think that it starts with kind of a basic assumption that it is a difficult one, frankly. The assumption is that organizations know where all of their data lies. The assumption is that they know what data they have, they know what data it resides where, they know what systems access that data, and then they assume that they know what other companies have access to that data. In other words, the assumption is that all things are known with respect to information. And I think the practical answer is that that is a really difficult assumption to make, yet it doesn't stop regulators and legislators from making it. Because most organizations have at least some visibility into their data. They have some visibility into their architecture. They have some visibility into their vendor relationships and supply chains, but they often don't have full visibility into that. And so that is the number one pain point, which creates a real challenge under these rules. Because if the rules themselves suggest and require that US organizations know exactly where their data lies and who has access to that information, and they feel as though they don't have that today. As a result, organizations are then put into place, and what the rule requires is that you do the diligence that is necessary to be able to understand and to address that assumption, to understand where that data now resides. And so, what we're seeing from global organizations is that they're becoming much more exacting in how is it that they are evaluating their business partner relationships, and how is it that they are understanding how data moves out of their environment, or how data is accessible in their environment, or who is collecting what data on behalf of whom for all of their global partners, including those in India. Because one of the things that you may have seen from the prior slide was that the list of countries that are named as having adversarial relationships does not include India, of course. However, what it does mean is that if an organization in the United States is partnering with an India-based company, and that India-based company transfers information to its vendor in China or its vendor in Russia, then that could be in scope of the regulation. In fact, if the United States company knew that that was happening, or more importantly, should have known that it was happening, then the United States company can be in violation of these rules. So importantly, what I just said there makes a big difference. It's because the standard is know or should have known. In other words, did the United States company know that the data was going to become accessible to that vendor in China? Or should it have known that that data would have become accessible? That should have known puts the real onus on organizations in the United States to know wherever their data is going and know how their systems are being architected. But it doesn't stop there, because those companies in the United States similarly to need to know how their India-based vendors are transferring data, or how their India-based vendors are allowing for access to information, because that also should have been known. And that extension of the diligence requirements means that this rule, while you may think of it just applicable to the United States, will have far-reaching application to all other companies that are involved in the global ecosystem, for them to understand what data they have, where that data is accessible, and to whom that data may be accessible. And that is a real struggle. And frankly, the pain points that you were describing a moment ago become highlighted when it is that these questions become central to commerce, not only today, but more importantly in the future.
Thank you, Scott. It's really amazing to know that you should have known, and then the vendor needs to know, and then the company is supposed to keep a track of what is happening and how it's happening. It appears to be a mixture of strict liability along with back-to-back liability. Appears to
No,
be quite a
100%.
confusing.
It's
Yeah,
And they wrote it that broadly intentionally to provide kind of that ability of saying, no, you can't just stick your head in the sand. That doesn't really matter, whatever was top of mind. We're going to look at all of the facts and we're going to look about how is it that you're engaging in global commerce. And if you should have known that that data would become accessible in China, that's not an excuse for the fact that you didn't know.
right.
That looks like strict liability.
Yes, and even DBDP Act that also works in similar fashion. That one cannot just do away with the liability. The liability remains strict. Moving on to Mr. Jain, the next question. My next question to you, it goes out to the heart with respect to the legal mechanics. Contractual safeguards, we have already spoken about the regulatory aspect of it. Now it's time for contractual safeguards such as SCC, like you were talking about before, which is standard contractual clauses. They are still very central to international transfers. But CRAMS 2, for example, has made clear that contracts cannot by themselves neutralize broad surveillance laws in the recipient country. So the real issue is whether legal documents can ever solve a structural problem of sovereign access when the importing jurisdiction permits extensive government access, what supplementary measures actually work in practice? Encryption, pseudonymization, split processing, access control, or data minimization? And at what point do these measures become more symbolic than effective? This is particularly relevant for multinational groups that rely on centralized IT systems and shared cloud infrastructure. I'd be interested to know your views on how far organizations can realistically go in preserving global data flows without fragmenting their operations. Off to you, Mr. Jain. Mr. Jain, you're muted.
See, definitely we need to understand the balance because as a compliance mechanism, we need to follow the standard contractual clauses, and that is also trying to follow Section 46 of EU GDPR. So, in order to a lawful transfer mechanism, you need to follow SCCs, which are the contractual obligation related to confidentiality, security measures, purpose limitations, or protection of data subject rights. So that is there, but definitely post STEM 2's judgment, it has been identified that even if you are having a standard contractual clauses in your data protection agreements, then also the state's surveillance and intelligence gathering powers are unlimited, and that actually creates a disproportionate access, and there may be a violation of data subjects rights. So of course you are understanding that SCCs needs to be there, but at post scrum 2 judgment it seems like that you need to understand if there is a unlimited surveillance and intelligence gathering power with the state, you need to understand there has to be a transfer impact assessment need to be done so that you know where you are delving into that particular territory, and need to take the sufficient guardrails in terms of understanding what will be that TIA assessment will bring you in. So definitely, with respect to TIA, you need to understand that supplementary safeguards in terms of, as you have already said, encryption, pseudonymization, split data processing, strict access controls and data minimization measure needs to be followed. So, of course, you have followed SCC in order to transfer data to a particular jurisdiction, but post Shrem 2's judgment, it was identified that SCCs are not in itself adequate. You need to have the TIA impact assessment so that you know that where you are going into and how you can take care of the data principal or data subjects rights interest catered into that particular territory. So additional supplementary safeguards also needs to be put in place. But having said that, of course, you cannot take care of the state surveillance and intelligence gathering power because they are there and they have to be, they are sovereign in terms of getting the access to such kind of data. So that restriction will not be possible because that will happen. But finally, I would like to say that contractual safeguards are the standard with respect to important criteria in terms of compliance needs to be followed and regulating the commercial relationship between the parties, but it cannot independently guarantee the adequate protection from the where the importing country permits extensive state surveillance without effective oversight or remedies. So you need to follow the standard protocol in terms of putting the SCCs in your DPAs, but definitely the state sovereign powers are supreme, which needs to be taken into consideration. But TIA assessment will actually brings you your understanding clear that where you will be post that surveillance happens and the rights of the individual may got violated in that scenario because states are supreme in their own categories.
Right. Uh, Thank you, Mr. Jain. Now, I think what we can say here is compliance should not just be done, it should also be seen to be done, so to speak. In the same vein, I have the next question for Scott. Uh, See, we have already talked about risks, control over data access, clear governance, and a credible explanation of practices. Now, my question is, how do regulators they measure whether those elements are real and not just documented for the sake of it in a policy folder? In your experience, what evidence tends to reassure regulators the most? Technical access restrictions, governance committees, audit trails, contractual controls like Mr. Jan talked about, or a combination of these things? How should companies think about the burden of such explanation? Is it enough to have good internal controls, or do they also need to be able to tell a persuasive external story about what they are doing and why? Uh, Scott.
Yeah, I think that is a really important question because if you are in the position of trying to be able to address a national security concern versus a privacy concern, we are far beyond a check the box type of approach to compliance. The EU model of having the right type of standard contractual clauses in place with the right type of data transfer impact assessment and the right type of supplementary measures and the review of the national security laws of whatever jurisdictions. Those are kind of key, items the way that the Europeans have set themselves up. However, that is not the framework to address a national security concern. Uh, the national security concern goes much deeper because if you were to look at some of the prominent examples that are happening in the past and right now in the United States, they are very much focused on the relationship between the United States company and the foreign company. And importantly, The standard is not necessarily, is this piece of paper in place or did you do this type of analysis? It's more of prove that this data transfer is not going to result in an impact on the national security of the United States. I mentioned earlier that there was, the interest in this has been at both the federal government and then at the state government. The state government provides a real important example of this because the state of Florida, amongst some other states, have imposed a set of requests that went to a bunch of organizations, a bunch of companies that were based in China. And they claimed that those Chinese companies, for the mere fact that they were collecting data relating to those individuals in those states, would be in violation of consumer protection principles. That information was not being that was not being safely and appropriately processed by the company based in China. And so, as you can imagine, they were not asking, did you have these five pieces of paper? They were asking more fundamental questions. How is this data being transferred? How is it being protected? How is it going to be that we can be able to trust you, company, in being able to operate in the United States, being able to access US data? And to do that, right, that is a much higher standard than I think what the Europeans have required. And it means that organizations really need to look at one important thing and one important thing only. How can they establish trust? How can they be in a position where they can demonstrate that organizations that are operating out of the United States are not going to create national security threats to the United States? And so that means that it's really important to build out the story that you are understanding the US concerns, that you have anticipated those particular issues and proactively addressed them. And then being in a position to be able to pull all of that together into a narrative that you can then show to any regulator to indicate, listen, we are not the ones that are creating these concerns. Somebody else may be, but it is not us. And it is important to do that both in a way of being proactive, but also in a way that is going to be documented. In other words, much like everything else, if you are not in a place where you have documented how you are addressing these issues and put that onto paper in a compelling narrative, then you may not get credit for doing so. In other words, you may end up having really great practices, but if they're not in a position where they have been put into a one particular place that can be accessible to those regulators or to those business partners, then all of those good practices may not get the credit that they deserve. And if I'm explaining anything else here, there's a lot of things to do and lots of things you can say that they're checklists. And I get that value is that I love checklists myself. But importantly, this goes well beyond that. And working from a checklist of this piece of paper, that piece of paper is part of it, but it's much more fundamental. And it goes down to the basis of being able to demonstrate and document and being able to tell a compelling story to those third parties to say that this data is safe in our hands. Thus, we shouldn't be the target of any questions or inquiries that you may be making.
Very insightful, Scott. So when it comes to our clients also, when they ask for advice, we always tell them that they should not look it as a compliance exercise, but as a trust building exercise. It shows intent and overall a very good business decision, if you ask me. Uh, so this is going to be the final question for the evening, and the question is directed to Mr. Jain. After Mr. Jain answers the question, the floor would be open. If there are any concluding thoughts, both the speakers can do the same. Off to you, Mr. Jain. My question is about the future of India's digital economy and AI ambitions. India has positioned itself a major destination for technology services, analytics, and data processing. We have been among one of the top players in the world when it comes to this field. But these industries they heavily depend on the ability to A receive, B process, and C move data across borders. The data is very important for the IT industry here. At the same time, the global trend is now moving towards tighter scrutiny of data movements, especially for sensitive data sets. The US Data Security Program, for example, which took effect last year in April, it treats access to Americans' bulk sensitive data, like Scott was talking about, as a national security issue, and it effectively operates like an export control regime for certain data transactions. So the question is whether India can continue to attract global AI and digital business while foreign jurisdictions tighten transfer rules. Does India's relatively open transfer stance become a competitive advantage, or does the border fragmentation of data governance ultimately force India based firms to redesign their technology stacks and business models for different markets? Off to you, sir.
Thanks, Shubham. So, see, I believe India's ambition to become a global artificial intelligence hub, with respect to analytics or data processing, depends heavily upon the continuous access to large-scale cross-border data sets, which may be used for machine learning, which may be used for algorithmic data set training, which could be used for cloud computing and digital delivery services. Having said that, I believe that there has to be a free flow of data, and definitely um, European Union's Scrum judgment and US data security programs indicates that sensitive data sets needs to be strategically linked, and of course they are with respect to national security, technological competitiveness, and data sovereignty. So, having said that, India, business needs to increasingly establish region-specific processing systems. They must have segregated cloud environments. They need to have localized compliance framework, and of course, they need to continuously operate with a restrictive foreign trade transfer regime. So, of course, you cannot be segregated in this global environment. You need to understand what are the requirements from these, advanced economies, and you need to accordingly, strategize your AI strategy or AI mission as per the government of India. Finally, what I believe that India's approach, or the environment in terms of the law is in place, is comparatively flexible, which enhances the cross-border data transfer, and DPDP Act actually strengthens its attractiveness because of the a negative list, which has to be notified by the government on a need basis, and therefore India is considered as a destination for global technology investments and international digital operations. Um, since the restrictions vis-a-vis other advanced economies, we need to understand that we need to follow the rules and regulation in terms of SEC, in terms of supplementary measures, in terms of transfer impact assessment, because because uh, those regimes are providing reasonable security safeguards to the data subjects and data principals. Therefore, I believe that considering the balanced approach and the restrictive negative list given on a need basis to be notified by the Government of India as per Section 16 and Rule 15 of the Data Protection Laws of India, I believe that India's future competitiveness of AI and digital economy may significantly depends upon its ability with respect to balance regulatory approach, credibility, international interoperability with respect to uh, Executive Order 141117 or Schrems 2 judgment, or with respect to SEC, TIAs, and all, as well as balancing the very important aspect of national security concerns because of the surveillance and the encryption traceability norms of the countries because of the cybersecurity requirements. And uh, India will be definitely be having a continued participation in the global data ecosystem because of this approach India is having in terms of a very balanced approach, and negative list which will be notified on a need basis by the government.
Right. Thank you, Mr. Jain. So I have a closing question for Scott. I know it's been a long session here, so I just have a couple of more questions. So, very simple questions. If you were giving one piece of advice to any India-based businesses that want to enter the US market today, what would it be and why? And number two, what is the single most common mistake that you have seen when companies they try to respond to US data transfer and national security expectations when it comes to foreign entities? Off to you, Scott.
Yeah. So the one biggest kind of area of say of advice, and even frankly, what the rule describes as it says, know your data, know your counterparty. In other words, it says you need to know what information you are receiving. You need to know what information to which you have access. And then importantly, you need to know who is on the other side of the table to be able to access that information once you know it. And that's going to be the standard for the United States organizations. And as a result, that is going to be the standard that they will extend to India-based organizations, and the standard that then India-based organizations are going to have to extend to all of their counterparties. Know your data, know what data it is you have, and know who's on the other side of that. And that's not only, who is the owner of the company in India, or the owner of the company in China, or the owner of the company in Russia, but who their vendors are, what access they have to the supply chain, wherever that data may be moving on in an onward direction. That is probably the most important thing to do, in terms of getting this right. A common misconception is that you can be in a position to react when it is that the company is getting those inbound inquiries, and then be able to address those things when those questions come in. That is by far too late. Uh, Effectively, when you're having a national security conversation and there has been a flag about the national security of using your products and using your services, it is very hard to convince somebody that you are not a national security threat. That is almost impossible. And so, if you can see the examples of companies who have gotten this scrutiny in the United States, you will see that the die, frankly, has already been cast when it is that they are getting those first letters. So the important aspect is to learn from that. And that means being proactive in how is it that you are addressing these concerns before anybody flags it to you as a concern. And then once you are in a position of showing that, then frankly, there is limited time and limited resources. And that means that there will be a focus on some other company, some other organization, some other country that will have access to this information. But that means that there's some work to do up front, even if it doesn't feel like the most urgent thing that you are doing. That is the most common mistake that organizations have when facing the government.
Thank you for the answer. With this, I now believe we can close this webinar. I really thank both of you guys for giving your valuable time to us. And if if anybody who is attending the webinar, they have any questions, they can reach out to either one of us. We are easily reachable. And good evening. Thank you so much, Scott. Thank you so much, Mr. Jain.
Thank you. Thanks,
Yep.
Shubham.
Thank
Thanks,
you for
Scott.
having me. Thanks, everybody.
Bye bye.
Thanks. Bye bye.